Okay, sorry about that. I think I'm finally live on Rumble. I'm not 100% sure, but I believe I am indeed live on Rumble at the moment. Excuse me. I was unable to make that happen yesterday, so I think I may have gotten that figured out finally. Okay, so apparently the court went in session before the camera crew was ready. So we're starting in the middle of a conversation, but I'm sure, well, hopefully we'll be able to figure out what it is they're talking about. And apologies if there's any problems with the stream right now, just give it a few minutes. As soon as I started the stream, a huge thunderstorm just is now on top of us. And I'm on Starlink. So thunderstorms and Starlink don't get along very well. If we have some problems, just understand it's going to pass it's going to pass over us pretty quickly. But if there are any problems, blame Elon, not me. Anyway, let's get started.
Ensure clarity regarding the expectations governing today's proceedings. Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos.
My role is for video in accordance with the court-to-court order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley.
Megan Thackeray with KSL.
Thank you. Have you both reviewed the court standing decorum order?
Yes.
Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order?
No.
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders, and they acknowledge that they understand the order and that they can comply with it, and the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it.
Just checking to make sure you guys can still that you can hear the audio in the courtroom.
We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that, but my point.
Okay, sorry. It took me a while to catch up there. Like I said, there was a huge storm coming through when I started the stream, and I mean, I thought the house was going to blow down for a moment there. But at any rate, I figured out what he's talking about. There was the letter that Tyler Robinson wrote to his significant other was accidentally leaked yesterday on the screen, and many people paused it and figured out what it said. I probably should have done that, but I didn't. I did notice that it was on the screen for a moment there, but I'm pretty sure that we've heard what's in that letter before. But at any rate, Mr. Poodlehair over here is gonna do whatever he can to use that to make this a mistrial or whatever he can do to get his foot in the door on ending this. That's what he's gonna do.
It doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this, so I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning, and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then obviously if there's a part two, then therefore.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published. Before the exhibit at issue was also brought onto the screen, I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down as soon as they realized that an exhibit was on the screen. I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well, in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media, and so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Sorry, I was muted. Anyway, I just wanted to say some of the things that I wanted to say when I started the stream, but if you weren't here at that time, I'll explain again. Huge thunderstorm coming through here, and it was, I don't know, I thought I was going to have to go down to the basement for a second there. At any rate, the things that I just neglected to say at the beginning of this is Something else that you may have heard about this too. It's all over the internet today. Is and before I even explain this, let me just preface this with the fact that I know nothing about firearms. I know absolutely nothing. That doesn't mean that I'm not pro 2A. I definitely am. In fact, I think that most of the regulations, or probably all the regulations, need to be rolled back significantly. But I have no interest in them, in firearms, and I don't own any. But something that was brought up yesterday after all those pictures of the bullets that we saw, was that yesterday? I can't even remember which day it was anymore. But we had been talking about or I had been talking about the engravings on the sides of the casings, but something that was brought up that I didn't know anything about was the tips of those bullets were like snub nose. They were, I guess, is called core locked. They're core locked bullets. They're designed to shatter and to not create an exit wound. And now that doesn't mean they won't do that they won't create an exit wound. Apparently, this is what I've been told anyway. But supposedly these particular bullets that he used were not, they were meant to fragment inside and not come back out the other side anyway.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand it. There's two exhibits.
Good to see you, Spirit.
Those exhibits were used yesterday in part because the juxtaposition of those two exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all three of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that three-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examining.
Sorry, quickly, I just want to tell my buddy Spirit in the chat, no worries, man. This is all just practice. I actually just got the cable that I needed to hook up my second monitor this morning. So actually, I bought one this morning and realized I bought the wrong one, and then went back out and got another later in the morning. But at any rate, I'm set up to be able to deal with the audio issues as they happen.
On that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit. And recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live stream, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why.
Wow, this is actually pretty bad for the media. They're sort of groveling today, which is bad. I was totally on their side throughout the whole thing, and honestly, this really shouldn't be considered a big deal. But our buddy Mr. Poodlehair is going to make it one, regardless.
Working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are. But then on March 17th, March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection, and I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
So we're already in recess, but we will find where they're coming back, because we're pretty far back today. I think we're like 2.5 hours or so behind. So it probably won't take us very long to catch up. Wow, there you go. There's a nice close-up shot of Mr. Poodlehair's hair. I don't know if that's who that is, but my gosh, what the heck is going on here? There we go.
Be seated. Court is back in session, noting the presence of counsel and all parties. And where we left off is the court took a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate.
I think the judge he said something about September 26th or September 2026 being in the past. I think he said something incorrectly. But that it sounded to me like he said all, if not part of that letter has been. I'm pretty sure he said it was released last April. But I'm pretty sure that the stuff in that letter is not. I don't know. I could be wrong. If you know something about that I don't, feel free to put it in the chat. But I think at least part of that letter has been shown to the public already.
My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say, preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be. Just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests, there were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is
he wants the cameras out. He wants them out immediately. And I guess since the stream is still live and we're roughly an hour and 45 minutes behind, I assume he's going to lose this little argument. I certainly hope he does.
When the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying Motion 305 and grant it for the balance of all of the proceedings in this matter. Or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank
Thank
you,
you.
Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability.
This is very reassuring about the prosecution, because I was actually worried that they were going to take the side of the defense on this. But I kind of got the idea, you know, when they were showing those text messages on through pictures of the phone. They weren't just screenshots. They showed the picture of that crappy phone that kid was using. And at that time, I sort of realized that the prosecution is sort of playing the same game as the defense and showing this stuff for the benefit of those watching at home. And I think that's why they showed those text messages that way, to show that that these were real. They weren't made up like all the conspiracy theorists are sure. They saw those text messages and read them and said, "Oh, come on, people don't talk like that." But those are real text messages. And now the complaint is, you expect us to believe that, seriously, this is what they're saying today. You expect us to believe that those text messages are real when they're just taken on a picture on the screen of some crappy phone? It's probably AI or something. And it's like, oh my gosh. So the officer testified that they did indeed download all that stuff from the phone. They just chose to show it that way because it was already a big it was already a big argument over that over the past several months.
And that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
He's giving solutions. We can pull it back, do the 30-second delay so that if this ever happens again, we can cut the stream quickly. And that's an obvious solution, and it should shut Mr. Poodlehair up, but I'm sure it won't.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't every moment of every hearing deliver the result that we are intending to deliver. those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding, in light of the court's well-reasoned and exhaustive rulings after long briefing on all of this. The court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I am capturing all the points made in the argument right now.
Just trying to get past some of this rigmarole.
It's great care. This patient's, this issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions, and I want to give this the full analysis that it's due. So thank you again for your patience.
I'm not sure why his audio is so low today, but I've got it cranked.
Right. Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions.
This is why I need effects. I love that shot of from the Simpsons of Judge Snyder saying denied. We needed that.
With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction.
Of course, it's not going to be all good, right? This judge cannot make a hard stance on anything. He goes both directions every time.
As it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, when that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you
So we don't get to see any more evidence apparently, but we still get to hear what's left of the testimony. So I think it's more DNA garbage, but we'll find out shortly, I suppose.
wish, you may call your next witness.
Judge, we would like the benefit of the record before we start taking evidence today.
Yes, Mr. Grenander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, "so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence." There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, "Under this low bar, it may be difficult."
Wild Herb, I'll answer your question in just a moment. Wild Herb over on Rumble.
"Difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you.
I mean, this guy is right. This case is just devastating against Robinson. But I just wanted to mention that Wild Herb Ways over on Rumble just asked a very interesting question. Do you think Judge Graff is independent or biased? And I believe what you're saying there is you're asking politically, is he biased? You know, if he is, and I'm sure he is because everyone is, but he has been as unbiased as a human being can be. So I don't know that it really matters what his leanings are. There are plenty of people on the left, believe it or not, who think Robinson should be put under the jail. So there was someone in my chat just yesterday. Was that you, Adam, that mentioned that? Adam Purser? I think that was who said that yesterday. I could be wrong. If I'm calling you a leftist and you're not, or not leftist, if you're on the left, I believe is how that was put, and you're not, then I didn't mean to say that about you. But someone in my YouTube chat yesterday had mentioned that they were well on the left and they're in full opposition to Robinson and his ideology. So at the end of the day, I just don't know that it matters which political side Judge Graff is on, because he's doing this so fair. I mean, he's being more fair to the defense than he is to the prosecution, and I think that's probably because he leans toward the direction of law and order. You know, he doesn't like the idea of people just getting away with murder. You know what I mean?
Mr. Grunander, do other parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burt. And before I have you call the witness, just want to make sure that the media had I'm not sure if the media needs to be heard on Mr. Grunander's response. No, Your Honor. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Ms. Oliver.
So finally, the trial begins for the day, or not the trial, but the hearing will now begin.
And be sworn in. There's a water bottle to your left if you wish. Now, after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer so I want to make sure your voice is projected? Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence? Admitted paragraph. For instance, the next sample down, 1.2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your
Well, they
understanding?
That
muted
is my
that last
understanding of the court's ruling, yes.
And to the state?
They muted the one just before that we just saw, or that they just saw.
The actual monitors at council table and podium, any clarification on that?
Well, that's why I give my notation at the beginning of the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nye on behalf of the victim representative. We cannot see it in court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct.
Well,
Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing, and the presence without being able to see the exhibits again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
If this is your first day on this trial, watching this trial, this particular attorney, I don't remember his name. He's kind of the Principal Skinner type. This guy, he loves to sink his teeth into this dry DNA crap, and he's going to do everything he can. Who knows how many hours this is going to take, but he's going to go over every detail of this DNA report.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The words strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports
True, Ed McClendon. Very true.
in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty,
Correct.
correct? Now, when, you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. Page. Help refresh your memory on when you may have received this case.
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay, could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
Could I refer to my tables in my report?
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
So mind-numbingly boring. He's great for sleeping if you want to turn the stream on for a
With the exception of
nap.
the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for
Hey, apprentice, good to see you.
people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only?
Seem that the defense has any witnesses that are actually on their
Are you familiar
side.
with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
They're all hostile witnesses.
A guidance document for practitioners on what, to simplify it, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30. to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk,
Something I've noticed about this guy is in his arguments against DNA evidence, it's not just the idea that the people behind the testing were incompetent or what, like anything that he can throw at the wall and stick is what he's going for. But it's not just that. He's actually, some of his arguments actually sound like he's trying to say that DNA science is just garbage and should not be admitted in court. And I mean, I don't know. I'm no DNA expert, so I mean, maybe he's right, but who gives a damn? Have you seen the footage of this guy on the camera? Who cares about this DNA evidence? I think they have plenty of evidence to put this guy in prison. Over the past 4 days, we've seen tons, and as I said before, there have been decades and decades and decades of trials in this country before we knew anything about DNA.
here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded, so there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey that DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
And I'm not sure if I mentioned this or not, but just to remind you, this is the final witness. And again, I don't know how long it's going to take for this guy to ask his questions. Every time he gets up here, he just loves to hear himself speak. But so this could take hours, but this is our final witness. I'm not sure exactly what happens after that, but I'm hoping that the trials or that the hearing will actually be over a little earlier today. Mountain time is so far behind me. I'm 2 hours in the future.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you, say, hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands, I then went to pick up an exhibit, a gun, I touched the trigger of it, your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to, say, swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
I can't stress what a bad idea it is to have this guy doing all his questioning not only at the end of the trial like this isn't the end of the day, obviously. This is just the end of the hearing, not the trial. But almost every time this guy has come up to ask questions, it's been at the end of the day, and everyone's tired and they want to go home. And this guy just won't stop. And he's apparently going to have the whole day today. So good luck.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted.
His whole spiel is just so tedious.
The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table. I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
was-
not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go page to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
The thing is, he's just allowing this to be reiterated that their DNA their DNA was on these tools and all these items, and that it's been checked by yet another DNA specialist. So I really don't understand how this is helping him. I just don't get it.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes,
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
no, it looks like,
No, you were right, 154. Yeah, this is one, what's the exhibit on this? This is 154. Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to the
thing.
first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
I'm pretty sure these are all the same questions that he already asked the other 2 DNA experts.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found at that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you
It's like a rerun from day 3.
had a difference in sequence between a known and a question across many loci, would you exclude the person?
It
It's
depends
again,
on,
objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt.
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever?
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report you use the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least at least 5 contributors, at least one of which is male. And for 1-1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example,
Sorry about the audio there for a minute. He just suddenly started blowing out the mic. I don't know what happened.
approximately, in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in the favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review.
This is another thing this guy does. You might have heard me bitching about this yesterday, but he does this all the time where the judge will tell him to hurry up and he'll say, I've just got one more question, Your Honor. I've just got one more question. And he'll say that 50 times before the judge finally tells him to shut up.
The material and
So could you bring
question
up
can be rephrased.
one exhibit, Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go, I'm just trying to weigh whether we should take a break.
I will probably be, I will probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
Okay, so we'll have about 20 minutes more of questioning, and then they'll probably go to lunch. And then we'll do some fast forwarding.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories, and additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework, and additionally, we participate in twice-a-year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes,
And at the time you did the testing in this case, did you satisfy those standards?
yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report, and this is, it looks like report number, or exhibit number 30, if we can pull that up, just for the witness.
It seems like most of most of the prosecution's questioning or re-examining or cross-examination is the same as the previous ones to combat the exact same argument that has been laid out multiple times, which is not his fault.
Thank you, Kimberly. A minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
The worst part
1.3
is when
the
he
swabs of the trigger and trigger guard of the
when he
rifle.
finishes the
Going back to
cross-examination,
page 5.
Principal Skinner is coming back to ask more questions.
And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component, and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly, and 2.1 is the swabs of 1 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together, so I wouldn't be able to say.
Here we go again. This guy he's up here again. So we'll just strap in and see how long this takes.
Where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
Good to see you, McMonsterly, over there on Rumble. I see you, buddy.
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person, can't state it's infallible, can't state there's a 0 error rate, and you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
Wow, I'm shocked. I thought he'd be up there for hours.
All right. May this witness be excused. All right. Thank you, ma'am. You may step down. Anything further from the defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1 so that the victim's family can observe that.
Thank you. All right. Do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling? And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you.
Oh, wow. Okay. So I had wondered if he was going to testify. I was sure that he wouldn't. I mean, it's absolute suicide to do that. So yeah, he's definitely not going to testify, which was expected, right?
Ms. Visser. All right. In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Your Honor, Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we...
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right. Nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as it's switched to audio only, to the state, now my understanding there's no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right.
So
And,
yesterday,
to the stage, just let me know if you're ready. Let's go ahead and play it now.
yesterday they had made he had made the decision that he would play that clip of Tyler Robinson coming off the roof with it being all zoomed in. He promised he would play that for the Kirk family. But I don't remember if he actually said that he would play it for the public. I don't think that was the plan to start with, but I'm pretty sure that we've all seen that footage. So let's just move past this. We're not going to get to see it anyway.
Stay tuned. All right, and that concludes the playing of States Exhibit 12.1, video transmission may resume. Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right.
Wow, I had no idea we were going to finish up that quickly. I thought they were going to take lunch and we were going to come back and there was going to be a bunch of arguments or something. Kind of relieved. I mean, it's been a long week. This is the first thing I've ever streamed. So Monday was my first stream, making this today my 5th, which hopefully I've done a much better job today than I have on the previous ones. But if nothing else, that's it. That's all we have for now. So I guess we'll just move on. And in fact, before doing so, I think what I'll do is I had some extra things queued up just in case. And if anybody is interested, then we'll take a look at some of these things. First of all, let me play this guy's, he just has a short. This is the thing I was talking about earlier with the bullets that they showed. If you see that, the snub nose there, listen to what this guy had to say about it.
That were fired. And we have been wanting to know exactly what type of bullets were fired at Charlie Kirk. And here's the thing. The 30-06 fires many, many different types, from Full Metal Jacket to frangible and a Coralock and all that other stuff. But why would I mention Coralock? Well, it appears that's what this bullet is, with this blunt tipped right here. This tip here that's blunted is actually a Coralock tip. Why is this important at all? Well, let me explain. Candace Owens' own guest debunked her and said that if it was a 30-06 Coralock bullet, he could understand it doing exactly what he did. But don't take my word for it, guys. He's right here. Let's listen to him.
So, if it is true that no fragments left the body, then it will all be there.
It's got to all be there. It's an autopsy.
And so maybe we're not seeing the whole picture. Maybe some fragments did exit somewhere. I don't know. 30-06 though. I mean, I've had a guy that was a sniper, a Marine sniper that said he's seen all kinds of crazy stuff. And this is just last week. And he could envision a 30-06 Coralock possibly doing that, but
In the neck.
yeah,
That's the problem. It's the neck.
And there you go. And you see Candace trying to control the narrative, going in the neck, as if she's the expert, which she knows nothing about this. The guy who makes the foldable AR that she interviewed.
Sorry, I was muted. This channel is called Artie Trolls. You should check him out on YouTube. He's got some pretty good videos, and he's been covering this Candace Owens stuff for quite some time. Also, this
they're going to be hearing us talk today, and on
someone on this stream was able to read Tyler Robinson's letter.
Yesterday, while the attorneys were arguing the evidence.
So we're going to watch some of the live. We're going to talk about the highlights of yesterday and then especially today. Because like you said, I think, yesterday was really setting the stage for today. There's a
Mhm.
bunch of argument, and then the bombshell stuff really came today. But before we get into any of that, we know that you out there think that Ryan and me are the absolute best commentators. We don't chain smoke, we don't say mean words to women and all that stuff. So if you want to support us or that evil Smoky Man either, the best way to do so is through Rumble Wallet.
Mike's off.
See,
No
yeah.
overruling.
Right to El Salvador, enjoy Bukele's prison stuff that came out that the defense had been fighting over was sort of a lot of stuff that came from Lance Twiggs, who's the trans lover. So there was a lot of communications that he had with Tyler Robinson, plus then screenshots of text messages, Discord messages, and more details about the gun and ammunition. So what to you was the big takeaway thus far today?
Well, there were a bunch of big moments. They showed a Rule 1102, which is essentially a preliminary hearing rule, and they had recorded under Rule 1102 Lance Twiggs, Tyler Robinson's lover, talking about what Tyler Robinson had done in the day of the shooting and the day after. And this set the stage for the text messages that we saw later. And he explained that he received these messages and that Tyler Robinson was acting erratically, was pacing, walking back and forth. He explained that he had given the Dremel to Tyler Robinson for the purpose of marking bullets with various phrases that we've now seen. And that was a few weeks before the shooting. So this was clearly something that Tyler Robinson was planning. He called it a hunting trip when he was planning it. And then we saw the text messages, and that, I'm telling you, Rob, they hit differently when you saw Lance Twiggs and you saw him introduce them. And some of them were really chilling. You know, first of all, he said, delete this. I didn't mean to send that regarding the note. And we're going to get to the note later, because that was a bombshell as well. But then it was a long text message confession, Rob. I mean, he said, I did it. He said that he did it. And then at one point, and I mean, I really did have a reaction when he said this. In referencing killing Charlie Kirk, he said, I guess Grandpa's rifle worked okay.
Yeah, that I saw you. I was watching you and Andrew when you talk, and I felt the same way when I heard it, and then I saw your reaction, because it really, part of you. Now listen, I believe this guy's a murderer. He has his day in court. The defense will present a case. I'm open-minded, willing to hear it, but the evidence is pretty overwhelming so far that we've seen. Part of you, when you're listening to him and he's like, oh, I shouldn't have sent this, maybe I shouldn't have done this, there's maybe part of you that's like, look, moment of passion, this guy does something really dumb. But when you hear him make that post, like, I guess grandpa's, because they're talking about the rifle being old and his grandpa possibly using it, or his dad possibly using it to hunt, and he's like, well, apparently it works fine. You really do see how cold and callous he was from that. And it's chilling to watch someone who, you know, just hours before had murdered someone, and he's making jokes about it.
Yeah.
It doesn't show someone who's remorseful. And I'm sure that's part of the defense's strategy, is going to be like, look, he didn't do it, but if he's found guilty, he was remorseful. This goes to speak against that, even after having time to collect his thoughts. And I believe that that message exchange, correct me if I'm wrong, he's basically camping out, waiting to try to get the gun. So he's looking at law enforcement in the area, and he's like basically texting, I hope they move on so I could sneak in and get the gun. And so he's sober-minded. He's thinking, he's not acting like, you know, someone completely psychotic just doing lunatic things. He's planning this out. He's planning to get the gun, and he's making these comments at that point, not only admitting to it, but basically joking about the fact that he killed Charlie Kirk.
Absolutely. I mean, he's sending these messages. He's hoping to take the evidence and abscond with it, which, by the way, the murder is obviously the important bit, because that's what he could get the death penalty for. But trying to collect the evidence and run away with it is also a crime. And he's been charged with that crime. And he instructed Lance to destroy the note and the text messages. He said, delete the messages. That's also a crime. That's tampering with evidence. He also tried to prevent Lance from talking to authorities. So these are all separate crimes. But yeah, I mean, he was definitely in cover-up mode. And I got to say, I was talking to Andrew about.
By the way, this guy here on the right, Ryan Mullally, I believe is his name. You should also subscribe to Rob Knorr. He's like the greatest right-wing debater on the planet. And this guy, I don't necessarily agree with everything he says, but you should check his channel out. He's great. This guy is great. He's a lawyer. He's covering this trial, and he's extremely informative.
About this, the evidence does not suggest a criminal mastermind. What the evidence suggests here is a dumb kid, probably manipulated by the type of inflammatory language and ideology that you and I talk about in our show all the time. Now, that doesn't, by the way, when I say manipulated by this ideology, that does not remove any responsibility from him. There are sane people who hear insane speech and don't do insane things, right? Like sane people, when I hear someone say something crazy, it doesn't make me do something crazy. You got to be a crazy person to do something crazy. But I do think this is someone who drank the Kool-Aid. He drank the Kool-Aid. He thought that Charlie Kirk was a hate monger and he had to take him out. And that's exactly what he did. And he did it the way an amateur would do it. He didn't have a good exit strategy. He didn't have a way to get the rifle off of campus. It was left there to be found. He didn't think the cops were going to be all over the place, combing for evidence, preventing him from coming back to the scene. It seemed like an amateur hour job by a kid who's good with a gun, who is training. They showed the different targets he was shooting. He was practicing. In fact, they showed not only the 4 bullets with the engravings, but they showed another bullet called Test Round.
Yep.
That he had,
it was expended. Yep.
Expended bullet called Test Round. And by the way, there's DNA evidence linking all of these cartridges and bullets and the rifle to him, linking the towel that covered the rifle to him, linking the screwdriver found on the scene to modify or reassemble the rifle to him. So it seems like he was a kid who grew up shooting. He knew how to hunt. He knew how to shoot. He went on campus, maybe got a few lucky breaks, took a shot, and killed Charlie Kirk. And it was just a terrible, terrible tragedy committed by this fucking idiot kid and his very, very bad and dangerous ideas.
So let's go just real quick, rapid fire through some of the conspiracies, for lack of a better word, that I'm seeing today. The first is the continued claim that some of Lance Twiggs' DNA was on things. And so either Lance Twiggs is is working with the government, he was the actual shooter, or he's setting this up. What say you to that? The idea that, like, well, Lance Twiggs must have been involved.
I mean, I don't think there's no evidence that Lance Twiggs was not involved. We haven't seen that evidence. And there is certainly evidence that Lance Twiggs was talking to him about, like, is there a serial number on the gun? So in terms of like some cover up, he was communicating with Tyler Robinson technically, but keep in mind, he has immunity for those statements. So whether or not he did them, he will never be charged for helping in that regard.
On the question of the immunity, I'm just a layman. I'm looking into this, but he didn't receive like a blank slate immunity.
No.
He received immunity for the statements he was making and any possible charges that could drive for that. So, for example, any charge of like trying to help cover up the crime after the fact, he's probably immunized from, because him presenting these text messages that would be used as evidence from that, they can't really use that. That's the type of immunity. But if it would be later found out, like, look, he didn't tell us that he actually was the getaway driver and that he planned all of this and like drew it out, and he's the one who told Tyler Robinson to kill Charlie, he could still be charged for crimes such as that, hypothetically, if they occurred, right?
Yes, he has what's called use immunity. So his statements cannot be used against him in a criminal prosecution. And as you, I think, well put it, so the only crimes that it appears that there's evidence he committed was giving Tyler Robinson advice about how potentially to abscond with evidence or deal with the serial numbers on the gun.
And someone asked about this in the chat yesterday about Lance Twiggs' immunity, and I still don't really know that much about it, but according to what Ryan Mullally is saying, I mean, if it turns out that Lance Twiggs was involved in helping Robinson in some way, if they find evidence for that, then it sounds like his immunity is sort of null and void. It's only for the obstruction crimes and things like that.
His statement is the crime, so he can't be charged with that because that's the only thing that we know that he did wrong. If they find evidence that he was involved in some other criminal activity, or if they can prove criminal activity independent of the statement, then they can proceed and charge him. But I suspect they won't. There has not been evidence of him being involved in the shooting itself. And he did, from the text messages we've seen, seem genuinely surprised by what happened. He seemed surprised. He seemed to take it relatively well, but he seemed surprised that Tyler had done this and had confessed to it. So I don't expect that those charges are coming down the pike. One thing that was, I mean, this is not about the criminality, but it just struck me as very, very odd. If you imagine you're Tyler Robinson, this is your trans lover, right? And you probably, let's be real. I'm a lawyer.
I'm too hetero. I can't imagine it. Well, but yeah, I get it.
But no, I'm trying to be. I want to say allegedly, but like, let's be real. Like, Tyler Robinson killed Charlie Kirk. Like, the evidence is overwhelming, right? So allegedly, but it's overwhelming. So you're sitting there and you killed Charlie Kirk because of how much you love your trans lover and how you feel about this person and all these different ideas you have, right? And then you in the note you wrote, you called them Luna because that's the name they were going by. Then Lance Twiggs shows up on this video. I mean, the hair's still long, but he's wearing a men's suit, men's tie, going by Lance Twiggs. You know, like, it's not Luna anymore. Like, that had to be a weird feeling for Tyler Robinson.
It was being reported. It was being reported that Tyler Robinson looked distressed for the first time today when the Lance Twiggs testimony. It is clear the defense knows this is damning, which is why they are fighting tooth and nail. So a couple more questions about this. One of the conspiracies or claims from that camp that I see is, well, they haven't had a chance to sort of test the veracity of these text messages. My understanding is they would have been allowed, even at this hearing, to cross-examine and to try to test, if they wanted to make a claim like, where is your proof that this was our defendant saying this? Could have been someone else. They had an opportunity to make those claims. Now, granted, they could still do it at the actual trial, but nothing precluded them from trying to challenge and saying, we have evidence that we never sent these messages. Like, we have our phone that show. They could have done all of that, correct?
Well, so here's what they could have done today. There was an agent on the stand, and the law enforcement officer was explaining how the text messages were collected, that these are true and accurate photographs of Lance Twiggs' phone, that he was there, that people he knew were there, that they recorded everything. So they could have tested the officer on whether or not any of that was true, if he was lying, if it wasn't properly recorded, if it wasn't properly done. And they didn't. They let that go because, on my take as a lawyer, they fought tooth and nail to keep this stuff out of evidence and to keep it out of the public eye. They fought for 5 hours on that. Once it was in evidence, they wanted to move on as quickly as possible. They did not want to belabor this point. They didn't want people thinking about this point. So I think that was strategic. And also, the person that they will cross-examine at trial that they couldn't, just to be fair to them, is Lance Twiggs himself. Because we got Lance Twiggs' video statement, but he wasn't there. And at trial, they're going to cross-examine the shit out of Lance Twiggs. They're going to really go after that guy because that's, if they can break him, that's one of the chances that they could have to do some damage to the state's case.
Most definitely, when Lance Twiggs gets on the stand, he's going to have smeared mascara for sure.
So they're going to go after him unbelievably hard. But again, to the conspiracy theorists out there, and I see it really bothers me that I see lawyers doing this. This is not a trial. This is not a trial beyond a reasonable doubt. There's no jury. This is a probable cause hearing. It's like a grand jury indictment. They just have to say there's probable cause. There's reason to believe that Tyler Robinson did it. And you not getting to do cross-examination on hearsay evidence doesn't change that fact. This is the procedure. This is how this goes. And in a grand jury, you're not even present. Right. So like these preliminary proceedings are not meant to be fulsome trials. They aren't fulsome trials. And when lawyers try to mislead the public and support someone like Candace Owens, who calls it a show trial and a miscarriage of justice, they're really doing the public a misservice. And it pisses me off, to be honest with you.
Yeah. And I mean, it's entirely possible. Like, we have no idea what the defense is going to claim. Like, presumably at this point, the defense has to claim that they didn't send these messages. Or I guess you could claim they sent them in a moment of like distress, or they wanted to, maybe they sent it, this could be a possible defense. Oh, he didn't do it, but he thought his boyfriend would be impressed. So he sent this shit. But all the conspiracy people are just like, no, it's all bullshit. Lance Twiggs is in on it. And because At first, it was, I could pull clips up of Candace saying, Lance Twiggs was never interviewed by the police. Well, now he clearly was. And so it just goes to show there'll never be proof. Then it just moves on. Oh, okay. Then Lance Twiggs is in on it. Another thing that may come into this case, and I don't know if they're going to introduce it tomorrow or if maybe they can introduce it later, is the statements of the parents. Because apparently he confessed to his family. At least that's what's reported. And his family encouraged him to turn himself in based on him admitting, yes, I did this. I suppose if the parents say, yeah, that's what he told us, now they're involved. They also are paid off by Netanyahu or by the FBI. So that as we see more and more evidence that we were told by these people, it didn't exist. There's no footage of him in the police station. Yes, there is. There was no interview of Lance Twiggs. Yes, there was. The gun that was shown was a stock photo, not the real gun. That's not true. It was a real gun. It just continues to morph. Well, that's okay. That doesn't really change. That's just, and so it's the logical part of you wants to be like looking at this like, wow, it's getting to be overwhelming. Maybe cooler heads will prevail, but I don't think so. I don't think there's ever coming back for the people that have invested and gained so much like Baron Coleman or Candace Owens with this.
Well, the thing that the real tell for me is when they switch from verifiable conspiracy theories to unverifiable conspiracy theories, right? Because when they're saying like, oh, it's an exploding mic, or oh, Tyler Robinson was never there, or oh, Lance Twiggs was never interviewed. Those are all things that technically could have been true and we could have learned. But those have all been debunked. So now they're switching to, it's a multi-agency cover-up. Don't you know Mossad's in on it? It's Mossad and the FBI and you're a Fed slopper. Now that's unverifiable, right? You're never going to get someone to disprove the allegation that the entire federal government is in on it with the little hat people who are down here covering up their tracks. Like you're never going to disprove that, right? Because it's frankly speaking insane and you couldn't be disproved. There's no piece of evidence that you could give them that would disprove that narrative, right? It's impossible. So they're moving into unverifiable land because they know that all their factual stories have been debunked.
If you bring up my screen here, Mystery, this would have been better with Andrew here, who is definitely more experienced with firearms, but they ended up showing a photo of the ammunition that was used, and apparently it was a Remington head stamp on it. And let's see, this is from an account, Phoenix Ammunition, that specializes in ammunition. It says photos of the ammunition recovered by Tyler Robinson, and here's the photos. And he goes on to say, Remington head stamp on the case, and despite the somewhat low resolution on the photo, you can see the somewhat blunted nature of the projectile's tips right there. He says, this is the Remington core locked soft point round. It's specifically designed to deform, slow down, and prevent an exit wound. Available at literally every single gun store and sporting goods store that sells ammunition. In fact, 16 of 17 of the 30-06 varieties manufactured by Remington use some type of expanding, deforming, or fragmenting bullet. Only one of theirs is a full metal jacket. Here's the clip of them sitting on my desk. This would have been the most easily debunked claim of their entire web of lies, and it's really mind-blowing considering this is exactly what you would choose for an assassination. But yeah, I keep getting information from that Portland pizza boy. So this guy's claiming that, look, this particular type of ammunition is actually designed to basically shatter on impact and not have an exit wound. I think, to me, that is, let's just say the people that are normies that are believing that aren't necessarily like Candace Owens, but the ones that are.
Thanks, Grandmass Boy Pod. Sorry, I had to read that off the screen as I was. He just rated the stream over on Rumble. Thank you very much.
Following her, I think this is the single most radicalizing thing. Even friends I talk to that don't know much about guns are like, well, you have to admit, that's strange that there wasn't an exit wound. But it doesn't appear that it's that strange now that we're starting to learn about the specific ammunition that was used.
And Andrew came to the exact same conclusion, by the way, that it was a soft.
I'm assuming that's Mr. or Mick Monsterly's main account name. More than likely. Thanks, Mick Monsterly, if that was you.
Point like that, Andrew, when Andrew's looking at the rounds, and he took his time. The first one he saw, he didn't think was conclusive, but he saw all of them. And he's like, okay, I think I figured it out. And that's what he said, the exact same thing. Now, is it possible for this type of bullet to hit bone and exit? Yeah, it's possible. It's also possible to do what it's designed to do in fragment. And I think this claim got a lot of play because a lot of people like me are not particularly educated about firearms. So it,
and that describes me. I'm not educated on firearms, but I am definitely pro 2A. But I just wanted to say, go check out McMonsterly's channel. I recently, well, not very recently, time goes by quickly when you get old, but somewhat recently, I watched a stream of his, and it was like I want to say it was like a Saturday or Sunday afternoon. I was editing, and this guy was just out there outside in his backyard, fixing or expanding his chicken coop. It was just the most enjoyable, relaxing thing I've seen in a long time. Check his channel out.
And it's hard to debunk a claim if you're not in the weeds on the technicalities. If anyone's ever debated a conspiracy theorist, you've had the unpleasant experience of like, they're like, well, the earth's flat. And you're like, that's ridiculous. And then they're like, oh, are you prepared to deal with like my 100,000 talking points that I prepared my entire...
Wait, did I get raided by 2 people? So Grandmaster Boy Pod and McMonsterly, I will have to check out Grandmaster Boy Pod's channel. But you should check him out as well. Obviously, he's a good guy. He's definitely on the side of convicting Tyler Robinson, which is good enough for me for now, anyway.
Their life on this issue. So that actually can be a little tough if you're not an expert in the area and you're confronted with a web of lies that's carefully constructed. But yeah, this guy and Andrew came to the exact same conclusion, and it doesn't seem at all implausible to me that a hunting round, a round designed to kill with one shot and to have bullets that fragment rather than going clean in and out, would do exactly that.
I've hunted a good portion of my life, or at least been around hunters, and I never used a 30-06. I used a 270, but I asked all of my friends to use 30-06, and every one of them said the same thing. They're like, of course, we've shot a deer and it didn't exit. Of course. Like of course, not always. Sometimes there's an exit wound, sometimes not. So it's funny. It's one of these things that, like, in my neck of the woods, everybody is a sportsman. Everybody's out hunting. Like, it's basically a holiday. Everybody takes off week, the first day of whitetail, and no one around here thought it was that weird that hunts. My college friends that never use guns, they're the ones like, well, wait a minute. And I think that so much of it's just like believing just random internet sleuths, maybe movie culture where you just assume that, but the only other thing I wanted to say before maybe we'll get to some of the lives.
Can I give you 2 quick super chats because they're directed at you?
Yeah.
Our friend, our mutual friend, potentially criminal Sean, thank you so much, says
the idea that I'm working with Israel. However, if Israel feels that way and wants to put me on a curling team, that I'm all for. I'm infatuated with the sport of curling. So I would be down with that.
And then a more serious question from Double Sullivan. This is trouble. This is important that we've been the judge was, and the reason I say he likely will plead innocent is the evidence has been so strong. I don't think he's going to get a plea bargain from the state. I think that if the evidence came in weaker, maybe the state would have said, we'll take the death penalty off the table if you plead guilty. But at this point,
this is an excellent point. Knowing what this case that the prosecution has against this kid, I just at the beginning of this hearing, someone had mentioned that there was a good chance he was just going to plead guilty and then take a plea deal. I think Mullally is right here. I don't think the state is going to offer one at all.
I don't see why the state would take the death penalty off the table. Like, I think they've got him, and I think they know they've got him. So they're likely not going to give him a plea deal. He's likely going to plead guilty. This could, of course, change, but this is me reading the tea leaves. And then we'll have a full jury trial within 6
I mean, he'll plead not guilty.
Yeah, he'll plead not guilty, sorry. Yeah. And then we'll have a jury trial within 6 to 12 months. I think end of the year, maybe next spring, somewhere in there.
I just want to take a second to thank Coffee Time Live for rating the stream. Thanks for joining us, guys. Welcome to the show.
Thank you so much. I will add one little thing to this. I don't think this is likely. There have been times where people plead guilty without any benefit to themselves. Maybe he just doesn't want to go through a trial. Maybe he's emotional about Lance Twiggs testifying against him. And he says, you know what, screw it. I don't even want to deal with it. That does happen from time to time, but I don't expect that, especially
betrayed by his lover.
At this point, if I'm him and if I'm his defense team, I'm like, look, hopefully the maniacs out there have tainted the jury pool that you get one person that's just like, no, I believe that this is all impossible. Mossad did it, and that's a possibility. Two other quick things. One, I saw one of the Candace Owens type claims here was something to this effect. Now they're claiming that he confessed 3 times. He confessed to his lover, Lance Twiggs. He confessed on Discord, and he confessed to his parents. That's absurd. If you were going to confess, you would never confess 3 times. You would only ever confess once. What do you say to that?
Why? Like, on what basis? It honestly, this is like, it's kind of like, I see why Andrew is starting to come around to the idea that this is like some kind of leftist influence, because it is literally like arguing with a leftist. Like, when you're talking with like someone who's really extreme left, and you could debate them all till you're blue in the face, but all you really need to do is sit there and say, on the basis of what? Like, why would anyone think that? Like, why? Connect the dots for me. Like, if you did something,
Sorry, I was muted. And this guy, Ryan Mullally, should know the thing that he's talking about with the leftists. He should know, because I've watched a few of his debates recently, and he's had some pretty shocking debates with some leftists lately. Shocking in the sense that, like, it's unbelievable what they're willing to say on a live stream. I mean, just threats. It's totally disgusting.
just did something horrible. Why would you only confess to one person? Why would that be limited to one person? I'm not even sure what the theory there is. It doesn't. I haven't seen any studies on this. I don't know, Rob. I guess technically it could be a thing, but I mean, it seems to me that she's just asserting that on the basis of nothing. She's just making it up.
Yeah, and like for me, I don't know if it was her, said it, or who, but for me, here's the thing. I don't know. I'm with you. I haven't looked into the psychology of this, but I know this. People that have a guilty conscience, or not even a guilty conscience, like a lot of people have trouble keeping a secret, right? It eats them alive. They want to tell people. So it's like, oh, I'm telling mom and dad. I'm telling Lance. I'm writing a letter. I'm putting it on Discord. I mean, let's not forget, he turned himself in with his family, the day after the shooting? I mean, this isn't like some dude that kept a secret for 14 years and then all of a sudden, right? This is a person that likely would have been flapping his gums until he was caught, even if he didn't turn himself in, based on sort of the behavior that we're seeing.
Well, and it's not like the confession is the only evidence here, right? Like the confession confirms the fact that he was on the scene, that he scoped out the area. We've seen him on cameras. He was identified by officers, was identified by his lover. His plate was run. We saw his car when he came back to try to get the rifle. We saw the car on video. We have DNA evidence connecting him to the rifle. I mean, how do they explain that? His rifle with his DNA on evidence was found in the woods with a fired cartridge. Like how do you explain that? Right? Like
he's a patsy. He was convinced to go there. I mean, and again, none of it makes sense when you look at the grand scale of what here's one theory that I don't think is out of control, that Lance Twiggs is somehow involved, right? That he maybe he was encouraging someone ought to shoot Charlie Kirk, right? Maybe there's more to it than that. But the most, I still think this is absurd, but I guess the most sane version of this is it was actually Lance Twiggs that was the shooter, right? And he set up. Now, even if that's true, what's the big conspiracy then? That he's connected to Mossad? That he's connected to the FBI? So it's like all of this stuff anyways. If
we're all FBI.
Yeah, I don't get it. I don't get what they're trying to say, because they'll be like, how do you explain that Lance Twiggs' DNA was on this stuff too? It's like, well, because it was from products from Lance Twiggs and Tyler Robinson's home.
That's the dumbest. That's the dumbest one. Can you imagine that for a second? How do you explain that, Rob? You share a house with your wife. Yep. How do you explain that your DNA and her DNA are on your bathroom towels? Can you explain that, Rob? It's like, well, wouldn't it be actually weirder if it wasn't? Like
that's what I'm saying.
It's a fucking bathroom towel.
And what we're likely to see now. Again, one of the things that's hilarious to this is like the exploding microphone and Mossad being involved and all of this and that. Like, I don't think the defense is going to make any of these claims.
Of course not.
It's clear to me the first day that what the defense is going to try to say is like, look, there may have been another shooter, right? That wasn't, there might have been a low caliber gun, a handgun. We found this holster, and they're saying, isn't it true that anyone's allowed to carry a weapon on this campus? Yeah. So there's reasonable doubt. They're not going to go with the exploding microphone, right? They're not, and so
it's way too specific. They'd have to introduce evidence. They'd look really dumb. Like, imagine if they spent a week in front of the jury trying to prove the exploding microphone theory. Then the jury's like, well, there's no evidence of that. You're an idiot. And then the jury thinks you're retarded, so they're not going to listen to anything else you have to say. For a lawyer in court, especially in front of a jury, your credibility is everything. If the jury thinks you're lying, if the jury thinks that you're there shilling, they're never going to believe you. So yeah, they're not going to go for any of these crazy conspiracy theories. It's going to be like you said.
They're definitely not going to go for any of the crazy conspiracy theories. And I apologize. I was looking for a specific part of this video, but I don't think I'm going to find it. It's on Ryan Mullally's channel, Natural Law with Ryan Mullally. I would recommend checking this video out. It just came out 12 hours ago. It must have been closer to the beginning, and I must have skipped past it. But basically what it was is the third voice that you're hearing in this video, Mr. E, reads the letter that they accidentally leaked on the screen yesterday in the courtroom, and I think he did a pretty good job of deciphering what was written there. So if you want to hear that, you can check this video out for yourself. I'm going to go ahead and end the stream because the hearing is over, and I just thought I could quickly find that letter in this video, but I didn't. I was unsuccessful. So for everyone who's stuck with me all the way to the end, I certainly appreciate it. It looks like I've still got a few viewers over there on YouTube, and I've actually got more viewers on Rumble because there were 2 other channels that decided to raid me all of a sudden, and I appreciate that. But thanks again for watching. I guess we'll return for the rest of this in September, or not the rest of this, but the next hearing in September. I forgot which day he said it was. I think it was the 1st. But if nothing else, like I said, I appreciate everyone who's paid attention and been watching this hearing with me. I've basically been doing this because I wanted to get some practice live streaming before I started doing it on my other channel, Murder the Mouse. So, well, on Rumble, that's what I'm called. So if you want to find me on Rumble, the channel on Rumble is just Murder the Mouse, and it has everything from Mushmouth Joe and Murder the Mouse on it. But on YouTube, I have a separate channel called Murder the Mouse, but it's not like this content. You may or may not care for it. And no one is I'm certainly not going to be offended if my trial viewers don't want to watch my right-wing Simpsons retrospectives. But at any rate, we will return, I guess, in September. If I have anything to add to this or anything else that fits in